Welcome to Talk Testimonies. Today, we're doing a deep dive into a really interesting Supreme Court case, Mount Lemmon Fire District v. Guido.
That's right. And it tackles a question that seems simple on the surface, but really gets into the weeds of statutory interpretation.
Exactly. It's all about the Age Discrimination in Employment Act, the ADEA, and who it covers. Specifically, does it apply to state and local government employers, even really small ones?
Yeah, like a small fire district. And the whole thing hinges on how you define employer under that law.
So maybe give us the quick snapshot first. What was the main clash in the arguments?
Sure. So the absolute crux was the meaning of this little phrase, also means, in the ADA's definition of employer. The petitioner, Mount Lemmon Fire District, they argued, look, the law first says an employer is someone with 20 or more employees. They believe that this also means part, which adds states and political subdivisions, just clarifies that first part, meaning governments also need 20 employees to be covered.
Okay, so they wanted the 20-employee minimum to apply universally.
Correct. But the respondents, Guido and Rankin, and importantly, the U.S. government backing them up as an amicus, they had a totally different read.
And what was that?
They said also means does exactly what it sounds like. It adds a separate category. So you have the 20-employee rule for many employers, and then you also have states and political subdivisions covered, period, regardless of size.
Just added on, no strings attached regarding size for that group.
That was their core argument, plain text. They also talked a lot about how the ADEA relates or doesn't relate to other laws like Title VII and the Fair Labor Standards Act.
Okay, let's unpack that a bit more, starting with the petitioner,
Right.
Mount Lemmon. Why were they so insistent on that 20-employee minimum for everyone?
Well, they framed it as reading the definition holistically. You can't just, snip out one part. They felt the second sentence, the also means part, was elaborating on the first sentence, not creating a whole new class.
And they mentioned something about statutory havoc. What was that about?
Yeah, that was a big concern for them. They worried about established legal ideas like respondeat superior.
Which is basically the employer being responsible for what their employees do.
Right, exactly. And their argument was, if you suddenly apply the ADEA to tiny public employers without that 20-employee threshold, which often aligns with certain resources or structures, maybe you mess up how that responsibility works. They even suggested it could paradoxically strip some protections from public employees or create weird liability situations for these small entities.
Okay, so they saw also means more like incorporates or furthermore not in addition to.
Precisely. They also made a point about how the definition initially defines employer based on a person and then carves out exceptions for the federal government. They argued this implies states were originally under that person umbrella, which had the 20-employee limit tied to it.
So like 5 signals in the statute pointing their way?
That's what they presented, yeah. Looking at persons also means this affecting commerce bit and the legislative history.
What about the agent clause? That seemed to be another key piece for them.
It was. They argued that the mention of agent in the definition was there primarily to lock in that respondent superior liability, making the employer entity responsible, not the individual supervisor.
To avoid, as they put it, an absurd result of suing individual employees.
Right. They felt their reading avoided that absurdity and aligned, maybe not perfectly in structure, but in intent, with how Title VII handles employer liability.
Okay, that's a pretty detailed picture of the fire district's position. Let's switch gears. What about Guido and Rankin, the respondents? Their argument sounds much simpler.
It really was, at its heart. They hammered on the plain text. Also means, they argued, is additive. It just adds.
Like here's category A and here also is category B.
Exactly. They said, look around the U.S. Code. This phrase consistently introduces an additional category, not just a clarification of the first one. So the statute says employer means the 20-plus group, and it also means states and political subdivisions. Full stop. No size limit mentioned for the second group.
And they pushed back on the Title VII comparison.
Strongly. They highlighted that Congress handled government entities differently in Title VII. There, Congress amended the definition of person to include governments and explicitly kept a numerosity threshold.
Ah, so a different legislative choice.
Yes. For the ADEA, Congress amended the definition of employer, not person, used also means, and crucially, didn't add a number threshold for governments. They argued this contrast was significant, not accidental.
Did they lean on the FLSA, the Fair Labor Standards Act connection?
They did. They suggested the ADA is kind of a hybrid statute. It borrows the anti-discrimination ideas from Title VII, maybe, but its structure, its enforcement looks more like the FLSA.
And the FLSA doesn't have that employee minimum for private companies.
Not in the same way, though. It has like a business size threshold based on gross receipts for enterprise coverage. But the point was the FLSA framework, which the ADEA seemed to borrow for government coverage, didn't inherently rely on a strict employee count like Title VII did for governments.
Were there policy arguments, too, like why it might make sense to treat small government employers differently for age versus race discrimination?
They touched on that, yeah. Maybe suggesting Congress had reasons, perhaps related to local control or associational interests, to cast a wider net for age discrimination in the public sector. Plus, they noted the ADEA already covers federal employers regardless of size, and many similar state laws do the same for their own political subdivisions. It wouldn't be some radical outlier.
And their view on the agent clause differed too.
Right. They saw less about just respondent versus superior and more about potentially broadening liability to include entities, maybe like certain independent contractors who act as agents but might not fit the traditional employer definition.
Okay, and the U.S. government chimed in supporting the respondents.
Yes, the Solicitor General's office argued for the respondents, and they really echoed a plain text argument also means adds a category. They emphasized Congress chose the FLSA model here, not the Title VII one, for adding government employers.
Did they have unique points?
They raised a significant concern about loopholes. If the petitioner's view won, they argued, a larger employer could potentially evade the ADEA by outsourcing discriminatory tasks to a tiny agent entity with fewer than 20 employees.
The outsourcing loophole.
Exactly. And they also pointed out what they saw as an inconsistency in the petitioner's argument. Interpreting also means one way for the government clause and perhaps differently for the agent clause. They also tried to distinguish the ADA's agent language from the FLSA and FMLA, where similar language has sometimes led courts to find individual liability. They suggested the ADA's context might be different.
So during the oral arguments, what were the justices really zeroing in on? What were the hot spots?
Oh, also means, definitely. Back and forth. What does it really mean in this context? Is it additive? Is it clarifying? That was number one.
It's predictable, I guess. What else?
The agent clause. Lots of questions about what it does. Does it just confirm employer liability, or does it potentially rope in individuals? What are the limits?
And the comparisons between the laws, ADA, Title VII, FLSA.
Absolutely. Why the differences? Were they intentional? Should they be read together in pari materia or respected as distinct choices by Congress? That was a recurring theme.
Yeah.
And, the policy stuff crept in too. Should small towns be treated the same as big corporations? Does age discrimination warrant different treatment than race discrimination in this context?
And the usual debates about statutory history versus plain text, I assume.
Always. How much should legislative history or assumptions about congressional intent influence the reading when the text seems, at least to one side, quite clear?
This case really does put a spotlight on how technical statutory interpretation can get, but with, real consequences for people.
Definitely. We're talking about whether older workers in smaller public jobs, firefighters, librarians, clerks, have federal protection against age discrimination.
And it touches on those bigger themes, the relationship between different civil rights laws, and this fundamental question of who is responsible when discrimination happens.
Exactly. The agent discussion, even if not fully resolved here, hints at those larger debates about employer versus individual supervisor liability that pop up in employment law.
It really shows the tension, doesn't it, between sticking strictly to the words on the page versus looking at the whole picture, the structure, the potential outcomes.
That's often the heart of these statutory cases.
Okay, time for our signature segment, the 10th chair. If we were sitting as that hypothetical 10th justice, how would talk testimonies rule on Mount Lemon?
All right, donning the imaginary robe. Sitting as the 10th chair, I think we'd have to lean towards affirming the Ninth Circuit. We'd rule in favor of Guido and Rankin.
And the reasoning.
It really comes down to the text. The phrase also means seems most naturally read as additive in this context. The statute sets up one category based on size and being a person, and then it explicitly says it also means states and political subdivisions. To read the 20-employee limit into that second clause feels like adding words that Congress didn't put there for that specific category.
So, primarily a textualist approach.
Primarily, yes. While the petitioner, Mount Lemon, raised some plausible concerns about the aging clause and maybe some structural untidiness.
The statutory havoc idea?
Right. But those issues don't seem potent enough to override the, frankly, quite clear statement that states and political subdivisions are included via also means. Those other complexities around the aging clause. They can be tackled in future cases when they're directly presented.
So respect the apparent choice Congress made, even if it differs from Title VII.
Exactly. It acknowledges that Congress structured the ADEA differently regarding government entities and avoids carving out an exception for small political subdivisions that isn't explicitly written into that part of the law.
Makes sense. A clear textual anchor.
That would be our reasoning from the 10th chair.
Okay, that wraps up our deep dive into Mount Lemon Fire District v. Guido. And just a reminder, everything we've discussed, especially our take from the 10th chair, is just commentary and analysis for informational purposes.
That's right. It's definitely not legal advice and doesn't represent the actual views or the final holding of the Supreme Court.
We definitely encourage you to think more about the arguments and maybe even read the opinions yourself. It's fascinating stuff.
Absolutely.
Thanks for joining us on Talk Testimonies.